Hi, everyone. That has just reminded me that I think that I'm in the office and I think there is actually a scheduled fire alarm. So you may hear it in the background, at which point I will mute myself. So I'm just going to move on to the first slide here. I'm delighted to be here today presenting to you on this topic. Now, what I discussed today is actually something that I previously covered on a panel that I had the privilege to be on with Mark Arnold Casey of South Square Chambers. And I want to give him proper recognition here as a contributor to some of the substance of what we're going to cover today. Now, in a restructuring and insolvency in all of its various manifestations, the Financial Conduct Authority has a series of substantive rights, which are provided for in the Financial Services and Markets Act, FSMA. And in a series of regulations concerning matters from the special administration, winding up, or dissolution of banks to investment banks, building societies, and collective investment schemes, along with many, many others. The purpose of this talk is not to examine the rights that the FCA has in any great detail, which may come as a relief to some of you, but rather it's to look at a slightly softer topic, which is the FCA's expectations and the influence of the FCA in court proceedings. Moving on then first to the FCA's expectations. As an overarching matter, the FCA's strategic objective is to ensure that the relevant markets function well. It has three operational objectives. The first is acting in a way which advances what they call the consumer objective. The secondly, and in the alternative, it has the objective of acting in a way that enhances integrity, their integrity objective. And finally, the FCA aims to ensure that it discharges its general functions in a way which promotes effective competition in the interests of consumers. As the FCA continues to supervise registered or authorized firms when an insolvency intervenes, so it expects the insolvency practitioner as well as directors to comply with legislation, rules, and guidance. The FCA has issued the following guidance that I've listed on the slide, and these are of particular relevance to us here today. We have in May 2021, the guidance for insolvency practitioners on how to actually approach a regulated firm. July 2022, we see guidance relating to the FCA's approach to compromises for regulated firms. And finally, we have the FCA handbook, which provides guidance about the FCA's general approach to the use of powers and rights in insolvency proceedings. So looking first to the May 2021 guidance, the guidance isn't exhaustive. It is absolutely in no way a substitute for reading the handbook and other applicable legislative requirements, but it is a lot more user-friendly and helpful. What I propose doing now is going through some of the key highlights in the guidance. And in doing that, it's actually very useful to split them up as between pre-insolvency, entering into insolvency, and during insolvency. So in terms of the highlights pre-insolvency, the FCA clearly expects the IP to understand the business model and the firm's regulated activities, either on or very shortly after appointment. So it should probably be one of the first things that you try and get to grips with. Two, the FCA is concerned with the IP's ability to take the appointment, including capacity and independence. It also expects early engagement, even before appointment, with both the IP and the company. This you're going to see throughout this entire talk is a very strong and running theme with the FCA, and one that I would encourage you to take on board. Where consent requests are to be made, for example, if you wanted an out-of-court administration appointment, they need to be submitted in a timely manner. And also, it's important to remember that the FCA has a right to participate on hearing of any application for administration or special administration, and it expects to be given sufficient time to decide whether its participation is appropriate. I expect that will be dealt with on a case-by-case basis. but you can seek advice from that from any lawyers you have engaged. Court and creditor documentation should also be shared with the FCA at the earliest opportunity, and disclosure obligations to the market must be considered on an ongoing basis to ensure that steps are taken to prevent a disorderly market. Now, moving on to what happens entering into insolvency. Again, we see that the FCA expects regular updates. It expects to see key client communications in draft so that it can comment before they are finalized. And also, it expects an interaction with the Financial Services Compensation Scheme. Now, this is the compensation scheme, as I'm sure you all are aware, will frequently become a creditor in its own right on assignment of the customer's rights following payment of compensation. And it's also important to remember that there are some instances, including in relation to deposits, where it has a super preferred status. So again, you're expected to be interacting with this particular regulated entity. If we look at what happens during the insolvency, the FCA, this is relatively onerous. The FCA expects the insolvency practitioner to have a suitable claims process in place, including inviting claims from the entire population of customers who may be eligible for redress. Fine, it's relatively standard. The FCA also has rights to make representations at creditors' committee meetings, subject to any confidentiality requirements. The FCA expects that the client assets held by the firm should be treated in line with the client asset source book, CAS, and the IP will also be expected to operate at least two separate estates: the client estate, which is comprising client assets, and the general estate comprising the firm's assets, with costs accurately split between them. The IP needs to, again, communicate in good time if it is thought to be necessary to apply for a rule to be waived or modified, because compliance with the same would be unduly burdensome and waiver would not adversely affect the advancement of any of the FCA's operational objectives, which we covered at the beginning. And finally, the FCA takes a particularly dim view of phoenixing. It's got it in for phoenixing, and will question the fitness and propriety of individuals who are shown to be involved in it. And again, in terms of restructuring, it's also worth noting that if an IP is advising a firm on restructuring options, including, for example, a scheme, a CVA, a restructuring plan, the FCA should be notified in good time. Again, good time, I strongly expect, is going to be on a case-by-case basis, and something that you should certainly take advice on if you are looking at a restructuring. Now, moving on to the July 2022 guidance, this is a mere 25 pages, and if you are into reading guidance from the FCA, it's actually a pretty good read. The key elements, again, can be broadly summarized as follows. The FCA expects and requires, in fact, in accordance with its Principle 11, that firms notify them immediately. Again, there's not really a definition of what immediately is, and provide relevant information at an early stage if they are considering proposing a compromise, again, whether that be by scheme, CVA, RP. And that is part of dealing with the FCA as regulator in an open and a cooperative way. In particular, if firms propose a compromise in respect of redress liabilities, the FCA says that they should ensure that it is the best proposal that the firm can make. This includes the firm providing the maximum amount of funding for the compromise so that consumers receive the greatest proportion of what is owed to them. In terms of the FCA's role, having regard to its statutory objectives, compromise which unfairly benefit the firm and its other stakeholders at the expense of the consumers are absolutely unacceptable to it. In those circumstances, provisions should be made for redress in line with separate guidance. And generally, the FCA will be concerned if customers are offered less than their full redress, and the firm continues trading when redress liabilities, in fact, were caused by serious or deliberate misconduct. And as I said earlier, consumers should receive the greatest proportion of what is owed to them. I don't think there's anything particularly controversial in that. As regards engagement, again, we're seeing in this, the FCA expects early and continuing engagement. You cannot hide from the FCA. Preparing a compromise without first notifying the FCA is considered to be a breach of their Principle 11. There is an information shopping list to enable the FCA to conduct its initial assessment of any proposed compromise, including the identification of classes and anticipated returns, and how that's to be determined. A separate shopping list is provided to enable the FCA to conduct its full assessment, and that includes information relating to the structure of the compromise, its substance, the practical effect of any proposed compromise on relevant creditors, financial information, and other relevant information, which can include plans for communicating and engaging with customers. And if necessary, the FCA will use the statutory powers that it has at its fingertips in order to obtain the information that it needs. It also may appoint a skilled person to provide a report where it considers that further analysis of what is proposed is necessary. And it also expects the firm to engage with the PRA, the Financial Ombudsman Services, and the FSCS as necessary. In terms of its assessment of any compromises that you are thinking of entering, they're going to be assessed on a case-by-case basis. Some key considerations, I don't think these are exhaustive, are the treatment of customers, the outcome they receive, customers' information needs, how you're going to meet them, what they are, and managing conflicts of interest. Also, they're going to say, has the firm put forward the best proposal possible for customers? That is a central consideration. Is a better deal available? That is said to be consistent with, but in fact broader than, the court's assessment. So you should bear that in mind as well. And what is also going to happen after the compromise is entered into? In that regard, they're going to be looking at issues, pretty broad issues about market integrity. So it's quite onerous when considering a compromise, the amount of things that you will have to consider when engaging with the FCA. They're also going to consider whether the compromise provides a fair allocation of benefits and losses between all stakeholders. And also they'll want to know, do the customers have access to guidance on the compromise, including any alternative options? And where appropriate, the FCA will communicate any concerns to the firm and the court. Of course, if you have early engagement with the FCA, better that those concerns are communicated to you and you can address them, rather than the FCA deciding it's going to go straight to the court and then having to deal with it at that juncture. Now, as regards the FCA's participation in the court process, it does not have a statutory role under the Companies Act 2006, unlike the pensions regulator, but it will draw concerns to the attention of the court where it's appropriate. And it will consider whether the compromise gives rise to matters of public interest from the wider consumer protection perspective, which, as we know from earlier in the talk, is very important to it. Interestingly, the FCA, although perhaps not surprisingly, the FCA doesn't consider schemes of arrangement, and it doesn't consider restructuring plans business as usual. So it may charge, in addition, a special project fee to cover exceptional supervisory costs. And I think if anybody's ever been involved in particularly a scheme, one can appreciate how large and detailed they are. So a special project fee probably is not unreasonable, because it will take a lot of additional work to review and assess a scheme. Now, regarding a regulatory action, the FCA will always be alive to taking regulatory action against the firm and senior management, especially in redress cases that have been caused by misconduct. It could even prevent the firm from pursuing the compromise or take regulatory action following the compromise. And as in the insolvency guidance, the phoenixing is frowned on, and the FCA will automatically question, well, not automatically, sorry, they may question the fitness and propriety of those who engage in it. So that covers the guidance, or everything in the guidance that I wanted to cover, and moves us on to the second part of the talk, which is the court's view. So does the court listen to the FCA? And the answer to that is, of course, it does. Not only does it listen, it listens very, very closely. It will listen even if the hearing is taking place in the early hours of the morning. And as we will cover later on in the talk, it actually even listens when the FCA doesn't say anything. I think that the best way to illustrate the interaction is by referring very briefly to four cases. The first of which is, these are English cases, but I think that you'll appreciate that the style of the judiciary between England and Scotland is not so different that I wouldn't expect the same sort of attitude to apply in Scotland. First of all, we have Recard Protection Plan. So in late 2013, Card Protection Plan Limited, which was an insurance intermediary which was regulated by the FCA, it proposed a scheme of arrangement to deal with redress claims arising out of the mis-selling of policies that had been there to provide protection against the loss, theft, or misuse of credit cards, as well as against the misuse of cardholders' identities. There were 6.9 million policyholders, and the scheme was actually thought to be the largest of its kind at that time. So fast forward to early 2014, Justice Proudman, she sanctioned the scheme following the approval by the requisite majorities at the meeting. In fact, there wasn't a large turnout. The meeting, in fact, took place at Wembley Arena with a mere 1.27 million people turning up, which was 18%. They mostly turned up by proxy. But importantly, for the present purposes, Justice Proudman, in particular in her judgment, noticed that the scheme was promulgated in consultation with the FCA, which considered it in some detail and approved it. This was a massive judicial understatement. There had been ongoing and very close consultation on this with the FCA at all stages of the scheme process, including in particular in relation to the communications with policyholders. And as you might recall, I mentioned earlier, you can start speaking to the FCA before things even kick off. So don't be shy about it, because if you tee them up, that can be all the more to your advantage in achieving a smooth, timely outcome. The next case that I wanted to cover is the Re-All or Re-ALL scheme limited. I'm going to call it Re-All just because it's easier to say. So this was the Amigo Group. It was a provider of guarantor loans, lending to those who were unable to borrow from mainstream lenders. The first scheme it proposed offered an estimated about 10 pence in the pound to customers in respect of redress claims, but it left ultimate shareholders intact and unaffected, even though they obviously would have ranked behind creditors in an insolvency. And that scheme was approved by 95% of creditors who attended and voted, with the claims amounting to about 240 million. But it was opposed at the sanction stage, not by creditors, but by the FCA, who objected for a number of reasons, which Justice Miles ultimately accepted and refused to sanction the scheme. So the FCA said that the customers with redress claims were not given necessary information. to enable them to properly appreciate the alternative options reasonably available to them, or to understand the best way on which they were being asked to sacrifice the great bulk of their redress claims, while the ultimate shareholders were to be allowed to retain their shareholding unaffected. And the court, in fact, did not accept that the only alternative was immediate administration. The directors had not considered all the options, including market recapitalization to raise funds or conversion of creditors' claims to equity. So it is quite telling that the FCA can come along, in these sorts of cases and wield a significant amount of weight. And in fact, if we move on to the real scheme in 2022, Justice Miles was proved correct because an administration did not, in fact, follow immediately on, and AALL Scheme Limited proposed another scheme. Now, as I said earlier, the court listens even when the FCA doesn't say anything. And the second scheme that was proposed by AALL Scheme Limited is a case in point. So having failed before Justice Miles, the company put forward a proposal for a second scheme, and Lord Justice Snowden, in this instance, gave directions for meetings to be convened at which proposals were approved by the requisite majorities. That scheme then went before Justice Trower for sanction, and that judge noted the stance previously adopted by the FCA in relation to the first attempted scheme. So anyway, so we're back with Trower. So Trower's noticing that in stark contrast, the FCA did not oppose sanction of the second scheme, and it didn't appear by counsel, and said in correspondence that it would not be in furtherance of its statutory objective to do so. So it had been closely involved in the development of the new proposal, and the judge was therefore satisfied that the FCA would have drawn concerns to its attention if it had any. And he also said that while it was self-evident that the questions of the sanction was for the court and not for the FCA's attitude was a material factor in his assessment for some of the considerations he had taken into account in deciding whether he ought to sanction the scheme. So again, very interesting. Actually, interestingly, the actual outcome of this scheme was that it didn't actually succeed, but that was to do with funding conditions not being satisfied, not because it wasn't approved. Now, the final case that I wanted to bring to your attention is Wealth Tech. So this was an application by the FCA for a special administration order under the Investment Bank Special Administration Regulations. Wealth Tech was a management firm regulated and authorized by the FCA, but not to hold client assets, which it turned out it did, having agreed that it wouldn't. Some of which they appear to have been dissipated. So the case demonstrated a number of things. It was one of those exceptional cases where the basis of the application was not insolvency, but it would be fair, meaning i.e. just and equitable, to appoint special administrators. And where necessary, you should be aware that the FCA can move extremely quickly, and court papers and evidence in this particular case were prepared over the weekend. And the court as well, and as I'm sure you know, will listen at any time of the day or night if they have to. And the first hearing in this actually started at 11:30 p.m. on Monday night and finished shortly after 2 a.m. on Tuesday morning, which is, I'm sure, exactly how all of us would love to spend an evening. The court fashioned appropriate relief. So rather than make the special administration order ex parte, it appointed the proposed administrator as special managers with extensive powers, pending hearing on notice, which took place much later. Well, not much later. Sorry, that's absolute rubbish. It took place on the Thursday, which was the first day of the court vacation. And that judge made the special administration order and continued a freezing order against the founder of Wealth Tech. So far, so good. The court will always listen to the FCA. Does that mean that the FCA will always prevail? I haven't seen it fail yet in what it wants. while the FCA is focused on consumers, the court will be focused on creditors more generally. So that could lead to a difference of views, but this is yet to be tested. And I would be interested to know if anybody else has ever seen any punch-ups in between the court and the FCA. I haven't. So that brings me to the end of that particular part and on to my conclusions, which are pretty brief. I think that if you leave with one takeaway from this particular talk today, it is always recommended to engage early and actively with the FCA. This seems to me to be key in giving you the best chance of running a smooth and hopefully successful process, whatever that is that you're trying to achieve. And in absence of this, you may simply be storing problems up for the long run. You want to have a good and open relationship with the FCA so that you can build a relationship of trust and confidence with them. And it would be great to hear from any of you, either now or offline, of your experiences with the FCA. But otherwise, that brings my particular talk today to a close.
Okay, thanks very much for that, Sophia. Yeah. Oh, I've got a bit of feedback there. I'll just keep talking. So, yeah, first question is, we've got quite a few questions actually. The first one is about when do the FCA, we had a session yesterday speaking about banks and where banks sometimes have a sort of a specialist team that deal with distress. Is that the same in the FCA? Is that all these individual cases sort of put together within a team that have experience and knowledge of various procedures that you're speaking about?
So my understanding of the way that the FCA operates is that there are set teams who will deal with particular matters. Whether you get the same person for the duration of your appointment who is assisting you is a different matter. I have heard anecdotally that you do not. And I think that's, and I'm sure the FCA, if they're wrong, will correct me if I'm wrong, but my understanding, please don't hold me to this, is that often, I suppose, to get experience, employees in the FCA will move around different teams to gain experience, I guess. So it does, but they're all trained extremely well, and I am sure that there are people in each team who have been there for a long period of time who are able to assist. So that is my understanding of how it works. There are specialized departments, but you may not get a dedicated team to your case for the duration of time that you are appointed.
Okay. The next question is about information sharing, and if we have an appointment where it's an adverse creditor appointment, where we have perhaps limited information, but there might have been investigations going on previously where it's not the FCA that's done the appointment, it's somebody else. Do the FCA provide information on what they know about the entity, or is it very much just they expect us to provide them with information?
I have to confess, I don't know the answer to that, and I'd have to consider it offline. But from my understanding of interactions with the FCA, if they deem it appropriate, and if there isn't something subject to, say, confidentiality, there can be a sharing of information both ways, particularly, I would expect, if it is in the interests of achieving the objectives that the FCA want to achieve. My impression of the FCA is that they are not there to block. They are concerned, block a decent outcome, but they are concerned to ensure that the outcome meets the objectives that they have set themselves. So I suspect information can go both ways. But for sure, the information is expected to flow from the IP through to the FCA. I expect much more so than it is expected to flow from the FCA to the IP.
Okay. Another question is about, you mentioned that the FCA expects there to be engagement with the Financial Ombudsman and the Financial Services Compensation Scheme. Is there a joined up approach between those three entities, or is it very much you have to deal with them very separately?
You have to deal with it. In my experience, you have to deal with them separately. Yeah, it's as simple as that. You have to deal with them. You have to deal with them, each of them separately. I wouldn't expect there to be fluid sharing of information between them, but you should use your own judgment, I expect, on when to share with them pieces of information that you have got from another. So, for example, if you need to show the FCA that you've been engaging with the FSCS, then do so. But I would not expect that the FSCS will have necessarily shared the fact that they are talking to you with the FCA.
Okay. Right. A couple more questions. Do you think there's a tension for directors of distressed FCA regulated firms between their statutory duties to the company's creditors as a whole and the requirements of the FCA?
That's interesting, because that was the last point that I was touching on with the courts. There is scope for it. There is scope for that to occur. I haven't seen it yet, but that's not to say that it may not happen at some juncture in a particular case. So the answer to that is yes, there is clearly scope for that to happen.
Okay, right. The next question is quite wordy. I'm just going to read it. With such significant FCA scrutiny of and involvement in proposed compromises, there is likely to be huge costs, not only in preparing information, but also professional and other associated costs involved in interaction and possible negotiation with the FCA. Does this lead to compromises being considered as too costly or having undue risk attached to them for these options to be pursued and ultimately result in potential business failures that may have otherwise been avoidable?
That is a very interesting question. So schemes and RPs, because we all know, are very expensive anyway. RPs were always aimed, well, one of the purposes for RPs was that it was hoped that they would be used for SMEs, but that hasn't come to pass as regularly as I think people would have liked. So schemes are innately expensive. RPs are innately quite expensive. Irrespective of whether you are doing something, irrespective of whether you're doing a solvent or insolvent one, as regards schemes. Do I think that may result in compromises being made? Possibly. I mean, if you can't afford it, you can't afford it. So yeah, so I'm struggling here because when you look at it, sorry, I'm just thinking about this answer because it is such a sort of not loaded question, but it's quite a complicated question. Right. Number one, schemes are expensive, right? Irrespective of how much the FCA are going to get involved or not, right? So yes, you may not be able to afford to do a scheme. I think there's plenty of people who can't afford to do a scheme. So that's the answer to that one, which yeah, I guess could result in a business failure that could otherwise be avoided simply as a consequence of cost. Is that fair? No. Is there a movement to try and make them cheaper? Yes, that was RPs. It hasn't taken off as well as people, I think, would have hoped that it would have taken off. But time will tell on it. Do I think that the FCA adds such a significant layer of cost to it that it would destroy a scheme? No, I think a scheme's expensive as it is. I think if you can't afford a scheme at a base level, the FCA, I strongly doubt, are going to add such a significant layer of cost onto the top of it that you couldn't pursue it. That's by 2 pence worth, from my experience.
Okay, Thank you. Just there's a comment in the discussion forum from Claire Martin, just commenting on with schemes of arrangements and the extent to which the FCA would require additional statements, and also I think the importance of company advisors who have experience of dealing with the FCA. So I think that's it. So a few questions there, almost as many as the insolvency services session yesterday on policy and strategy. So thanks very much for
Thank you.
doing that for us. Very interesting. And yeah, thank you.
Thank you. Absolute pleasure.